I would like to thank the organizers for inviting me. I mean, it's a real honor to be included in such a prestigious lineup. And hopefully I'll be able to work out, because I'm technical illiterate, and I can still push a button. That's unbelievable. All right then. So the topic of my presentation, as you can see, as was graciously entrusted to me by the organizers, is the evolution of the definition of crimes against humanity under international criminal law. So, given that I only have 20 minutes, obviously I won't be able to dig very deep into some of the historical and definitional niceties of this concept. So, first, I would like to speak a little bit generally about the idea of humanity and what it means within international criminal law or in the system of public international law more in general. Then I will talk about the history of the evolution of the concept of crimes against humanity. After that, I will talk a little bit about the codification process, or more about the failure of the codification process. Then I zoom in on the Rome Statute definition, and finally I will end up with some controversial points. So without further ado, let's turn to the conceptual framework of the idea of humanity in international law. Now, I think we can say that the idea of humanity is really interesting in international law. It's very elusive. It's very difficult to define what humanity means. I mean, the very English word, or even the French word, humanité, is very broad. I mean, it can, on the one hand, mean some kind of quality of humanness or humaneness. On the other hand, it could also mean the collectivity of human beings as such. And the idea of humanity somehow invokes very different but related concepts at the same time. So on the one hand, we might say that, well, when we invoke the idea of humanity and something that is contrary to the idea of humanity, then we invoke something that's obviously inhumane, something that has already been invoked back after the Second World War, shocks the conscience of mankind, which is still in the preamble of the Rome Statute, of course. So it's something where all human beings have something like a shared consciousness, and we have shared values, and the breach of these fundamental values brings about this outrage, this need to punish certain acts. On the other hand, we could also think that, well, crimes against humanity should have a huge magnitude, maybe. They should not be just some local isolated incidents. They should be something that could be interpreted as an attack of not just specific individuals, but instead on the whole human race. Now, these different ideas are sometimes not completely compatible. And we also have to take into account, or at least heed the warning of Carl Schmitt, that invoking the concept of humanity can be used for bad purposes. I mean, of course, with Schmitt, I mean, it's kind of obvious. But apart from that, I mean, he says that, he basically said that whoever invokes the concept of humanity is trying to deceive you. I wouldn't go that far, but of course, the idea of humanity doesn't just have a transformative quality, it also has a disruptive potential. Because whenever we say that something is contrary to humanity, this also means, obviously, that we cannot deal with it. We have to completely destroy it. We have to approach it with criminal law and not political ways of settling differences. Now, the idea of crimes against humanity, of course, is revolutionary, because for the first time ever, we, or at least international lawyers and politicians agreeing with them, said that, well, I mean, certain acts which were committed by the state against its own nationals could be brought into the purview of international law. So it basically discussed the domaine réservé, which was the very basis of the Westphalian concept of sovereignty. Now, of course, this is not something that happened out of the blue. I mean, a conventional history always starts with the 1915 joint statement by France, UK, and Russia, in which, of course, they strongly condemned the atrocities committed against the Armenian citizens of the Ottoman Empire. I mean, as you can see on the slide, I mean, these three governments said that in view of these new crimes of Turkey against humanity and civilization, the Allied governments announced publicly to the Sublime Porte that they will hold personally responsible for these crimes all members of the Ottoman government, as well as those of their agents who are implicated in such massacres. But of course, invoking humanity and condemning inhumane actions was pretty common already in the 19th century. So for example, at the end of the Napoleonic Wars, at the Congress of Vienna, the final act of Vienna also invoked this very same idea of humanity and civilization when they prohibited slave trade. So already in the 19th century, we had this conceptual framework within which we could invoke humanity to justify prohibiting certain acts. But of course, this went a step further, because here it invoked the idea of criminal prosecution, which of course is a huge difference. I mean, after all, Napoleon was never prosecuted for certain acts which could have been described as crimes, to put it mildly. While 100 years later, we have the idea that maybe invoking humanity could come together with prosecution. Now, this has caused, of course, a lot of debates already. I mean, in the 1919 report of the Allied Commission, the Juridical Commission basically first wanted to introduce direct references to basically the Martens Clause, the elementary laws of humanity, but the USA representatives clearly objected it and matter-of-factly said that this would be moral law, which is not law at all, of course. Still, at the same time, there were some proceedings in occupied Istanbul against people involved in the massacre of the Armenians. So the idea did start to develop. But of course, we had to wait until the end of the Second World War to have finally a new category of crime that today we know as crimes against humanity. Now again, the adoption of this new category of crime was still very controversial. I mean, even the name crimes against humanity didn't exist, as far as we know from the Travaux Préparatoires, even in March 1945. And allegedly it was suggested by Hersch Lauterpacht, but we will never know for sure. But anyway, when it was finally adopted, the Allies were very much aware of its potential disruptive potential. After all, this was a category of crime that could have been invoked against the government. And of course, there were all these lofty aspirations associated with the Nuremberg Tribunal, where the Allies didn't just want to exact revenge. They didn't just want to exact victor's justice. They wanted to create a new legal order that would presumably apply to all states in the world, not just to the defeated enemies. So creating this new category of crime could very well have brought about perils. So no wonder that we see that this idea of crimes against humanity was very much circumscribed by jurisdictional requirement, but also by the way it was positioned in contrast to all other international crimes. This was the last international crimes. I mean, obviously, the crime of aggression or crimes against peace was the crime of crimes at the time. Genocide didn't exist, while war crimes had already been a well-established part of international law. So, crimes against humanity came third, and it came as a residual category, basically to cover atrocities which would not have been able to be prosecuted through crimes against peace and or war crimes. So it was a residual category. When everything else fails, we still have, as a fallback option, crimes against humanity. But what is even more important, and that was a strategic design, is that the Allies specifically tied the idea of crimes against humanity to the concept of war. And that time it was an international armed conflict. Make no mistake. The Allies didn't think that crimes against humanity could or should be applied during a non-international armed conflict. This is very clear from the text, even though it says before or during the war, which presumably suggests that it could be applied even for acts committed before the 1st of September 1939. It was never applied to that. And then we see this other proviso which says in execution or in connection with any crime within the jurisdiction of the tribunal, which clearly links it to war. And this nexus requirement, as I said, was a very deliberate design. And it was not just the Soviet Union that wanted this nexus requirement. It was all Allied states that wanted it. And we have some evidence for that. I mean, an archived letter between correspondence between Telford Taylor, who was the chief US military prosecutor in the subsequent Nuremberg trials, and Vice Secretary of Defense Howard Peterson. Telford Taylor, the prosecutor, said, "My own view is that departures from democratic systems as may exist in some countries and discrimination, even quite aggravated, such as may exist against N-word in certain countries, should not even in these enlightened times constitute crimes at international law." And Telford Taylor here was very obviously talking about the Southern discriminatory legislation in the United States against Afro-American people. So all the Allies were very much aware of the fact that the concept of crimes against humanity could be used for domestic actions as well, even actions which reflect established state policies. Now, no wonder we had to wait so long to have crimes against humanity pop up again. I mean, war crimes have been kind of codified immediately after the Second World War in the 4 Geneva Conventions in 1949. The Genocide Convention conclusively settled the definition of genocide. We still have the same definition of genocide as it was decided back in 1948. While crimes against humanity simply evaporated. Very few countries implemented crimes against humanity as a separate crime. We didn't have any general treaties codifying crimes against humanity. So we only had the International Convention on the Suppression and Punishment of the Crime of Apartheid, which arguably forms part of crimes against humanity, even though at that time it was very, very politically controversial, but nothing else. So we had to wait until the adoption of the Yugoslavia and then the Rwanda Tribunal to have crimes against humanity coming back again. And this time we can say they came back with a vengeance, at least when it comes to the ICTY, because in Rwanda, obviously almost all crimes were committed to genocide, so there was not a lot of need for crimes against humanity. But for the Yugoslavia Tribunal, crimes against humanity was a very important criminal provision. And here we again see the nexus requirement coming back very interestingly. Now, of course, the Yugoslavia Tribunal later said, already in the first studied jurisdiction appeal, that, well, that's just a jurisdictional requirement. But in customary international law, we have no nexus requirement. But it's still quite interesting that even back in 1993, the UN Security Council felt the need to include an nexus requirement, which again tells me that states were still somewhat aware of these potential problems. Now, with the Rwanda Tribunal, we didn't have the nexus requirement, which is quite interesting. But of course, the Rwanda Tribunal was always interpreted as a kind of domestic tribunal, meaning that it only applies to a conflict within a state, and it doesn't have a transnational aspect, which of course was never really true. Now, going back to the codification aspect, so between the Second World War and the adoption of the Rome Statute, we really didn't have anything meaningful in terms of codification. But what is interesting that since 1998, when Article 7 of the Rome Statute, of course, kind of conclusively codified the concept of crimes against humanity, even since then we don't have a lot. I mean, we had one international convention about enforced disappearance, but we still don't have, and I think we will never have, a general convention on crimes against humanity. Maybe in the future we will have. But it's still very interesting that even though we have the 1998 definition of the Rome Statute, which is generally accepted by states as reflecting customary international law. Now, we know that quite well because the International Law Commission recently adopted draft articles on crimes against humanity, and there are ongoing discussions in the Sixth Committee about the text. And most states agree, and by the way, these draft articles repeated verbatim Article 7 of the Rome Statute. So they basically copy-pasted the crime definition. Not everything else, but the crime definitions. And most states agree that this is customary international law, and yet it doesn't seem very likely that most states are willing to adopt a convention on crimes against humanity, which is kind of interesting. So let's take a look at the Rome Statute text very quickly to see why that could be the case. So we have crimes against humanity defined as any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. So it establishes contextual requirements. It establishes the requirement that it has to be a civilian population. And it mentions specific crimes, but this is not an exhaustive list because we have other inhumane acts. And other inhumane acts is the only provision in the entire Rome Statute where the statute allows for custom to define crime. So this was purged from the Rome Statute. When it comes to the war crimes, it was purged when it comes to genocide or aggression, but we still have it when it comes to crimes against humanity. Now, maybe in the Q&A we'll have some time to discuss some of the controversies. I would like to mention a few, though. The most interesting, for me at least, is the civilian population requirement, which is kind of weird to maintain it. Now, civilian population requirement was very, very understandable back in Nuremberg and Tokyo. Why? Because it was meant to be a residual regulation. So if we cannot try somebody for war crimes, then maybe we can still try that person for crimes against humanity. So of course we have to differentiate crimes against humanity from the more strict requirements of war crimes law, which have always been based on the status requirements traditionally. But I wonder whether this still makes some sense. Now, I don't have time to go into that, but I find it somewhat strange that the ICC was extremely brave, to put it mildly, when it comes to war crimes law, because in Ntaganda they basically said that, yeah, you can commit a war crime against a member of your own armed forces, which I think completely destroys international humanitarian law as we know it. But they didn't do anything with the same thing when it comes to crimes against humanity. I just wonder whether it would have made more sense to say that, yeah, civilian population requirement should just be a jurisdictional requirement and then applied even to members of armed groups, as opposed to just saying that, well, we don't really care about humanitarian law anymore, as it used to be. Now, I stop it here. I have a lot of other controversial things to bring up, but I stop it here, and maybe you can ask some things in the questions. Thank you very much.